Hello, everybody. You've landed here because you want to know what's next. After all the documents are prepared, the next most important thing is to get them witnessed, signed, notarized. Here is a mock signature event. You're going to get a lot of questions answered here. Some example of some of the things that people ask. So take a watch.
For that, we always sign in blue ink so that you know the original. So we always sign in blue ink. All right. All right. So I did the signature pages. I was not gonna draft an entire trust agreement for this. I'm committed. All right. So we got our signature pages for our trust agreement. So that is the document that says, okay, this is where, who the beneficiaries are, what all of the terms are. That's your trust agreement. We've got your pour over will. That's the will that says anything I forgot to put in my trust when I die goes into my trust. And then your certification of trust. So your trust agreement is going to be a really long document. Your certification of trust is like a 2-pager that you can take to the bank. So the bank's going to say, oh, well, I need to see your trust agreement so I can put the bank account in your trust's name. And you don't want to lug the whole agreement, plus that's none of their business anyway. So you want to have like a quick 2-pager with all the basics they need to know. So that's what we're just, and normally, by the way, there would also be powers of attorney and the things that George talked about. But we're just going to do these things right now. All right. So, Mr. Moneybags. All right, before we begin, there are some questions I have to ask at every signing. And I always tell people, do not joke. You maybe feel the need to like give a sarcastic or joking answer. And if you do that, you have to like leave and we have to come back another day and it's a whole thing. So, although I guess you're lying anyways, because it's not really your trust. So, have you read these documents?
Yes.
And is everything to your liking?
Yes.
Has anyone promised you anything in exchange for anything in one of these documents?
No.
And are you under the influence of any drugs or alcohol that would affect your decision-making ability today?
No.
Okay. All right. So you're gonna take your pen, you're gonna sign as the grantor and trustee, and then you're gonna pass it. And you'll sign first witness, sign in the correct name. I always do one full document and then one full document because I found when we just pass signature pages around, they get lost, they get mixed up, and it takes twice as long. You can't read their writing. All right, well, George is notarizing. We'll do our pour over will. So this one, if this were an actual will, by the way, you'd have to initial the bottom of every page. So you date right there. Today is the 8th of March. I should know that, the day that I've been planning on coming to talk. Right. And then you sign there and then pass it. And then you sign, and then you put your address, which I usually tell people that they can use their work address because they may not want to put their home address. That's fine. That has to be an address. It's a great question. She asked what pour over means. So pour over It means that under the terms of the will, they say when I die, I bequeath everything to my trust. So let's say that he forgot to put a rental property in there. We did, he's got 20 and we did 19 deeds and he just forgot about one. Well, when he dies, that rental property is not in the trust. So we have to know what's going to happen to it, where it's going to go. And the pour over will says everything goes to my trust. So that means that it just goes to the trust. So you can think about his estate. You can think about like an empty bucket and you start putting things in it. That's your trust. And then you've got another bucket and it's got some stuff in it. Well, when you die, the pour over will says, we're going to take everything in the estate bucket and just pour it into the trust bucket.
And also tell them about residuary estate, which is in the will country.
Yes, residuary estate, yeah. So you have in a will specific bequests in a residuary estate. Specific bequests are, I want my diamond ring to go to my daughter. I want my painting of my, Rembrandt painting to go to my best friend that I traveled the world with. And then the residuary estate is, and everything else. So I want everything else that I owned that I haven't specifically named. And you can say everything else goes to my spouse, everything else is divided equally among my children, everything else goes, to my spouse. And then if my spouse predeceases me to my children, or everything goes to my two best friends, 50-50, however you want to do it. But you can't disinherit your spouse. Well, I know. I have people checking you. That's right. You gotta divorce first. Or you get a prenup. Or you get a prenup. A prenup you can waive your inheritance rights, which I'm a big fan of. People are having like a second marriage and they have children, or they're entering with children from prior marriages or prior relationships. I am a big fan of prenups in that situation, so that you can protect the inheritance rights of your children and you don't end up dying and everything goes to this new spouse and then they die and their kids get everything and now your kids don't get anything. Can you leave them $1? You can leave them $1 well, your spouse, you have to leave them more. Yeah. No, you have to leave them more than that, I'm afraid. Yeah, there's a whole statute about everything they get, but it's their elective share. It's an elective share statute. The code for that, but don't know off the top of my head. I know they have to elect to take it, so they could choose not to. All right. This is our affidavit of subscribing witnesses. So a will is not good unless the witnesses, that's just you all, the witnesses sign and say that they meet all of those requirements that George mentioned for being a witness. And they sign that under oath. And while they're doing that, you can sign the certification of trust, which is the short document that you can give to a bank or whatever, so that you don't have to give them your entire trust agreement.
You want to, so if I'm leaving something to my child, say I don't want them to inherit until age 25, depending on completion of a college degree. Is that something that you put in your trust, or is that labeled in your will? Because I don't want to leave millions of dollars to an 18-year-old.
No, you do not. No, you do not. So the best thing you can do, best practice would be a trust in that situation. But you can do a will that says they'll inherit, at a certain age. Now there's this thing called the rule against perpetuities. Property must vest or fail to vest within 21 years of the life of being. There's like whole classes in law school on it. So, but they're a little bit more limited is what I guess I'm trying to say, and what you can put in a will with that. But you can put some parameters like that on a will. Yeah, but you can put more parameters in a trust.
Share TCA 31-4-102. No, just
all right, say it again.
31-4-102.
102. we got the question what the code for the elective trust was. So that's the code for that's the Tennessee
Try to
code
remember
for the
it.
elective.
Not
Elective share, elective trust, elective share for what your spouse has to get if they like. So if you had a will that says I disinherit my spouse, you can do that. And then if they just accept it, then that's fine. But they have a certain time where they can file with the court and say, actually, hey, I'm their spouse. I'm entitled to my elective share, and then they're gonna get what they're entitled to by statute. I know the marital residence is one of the things, but there's more. I really don't manage a trust, so I don't know the answer to that. There are, you might have a better answer, but there are companies who manage, who just manage trusts and they charge their fees. Or you can have a trustee that you know. So for example, I did a special needs trust recently, and the trustee was the uncle of the special needs child, and he's just doing it for free because that's his nephew. And
let's do this because I'm going to jump.
I know, we're over. I'm so sorry.
But somebody had a question, but I didn't see who it was.
This has to do with the spillover. And instead of itemizing everything that you didn't put in the trust, can you just say in everything provision? Yes.
Can you repeat the question?
Yeah, so the question was with the pour over, instead of itemizing everything that goes in the trust, can you just say and everything else? Yes, you can. That's the point of the pour over will, as it says everything else in the trust. I think. Okay, well, you're gonna list. Okay.
Safe deposit. You keep doing it. Well, a lot of times people will leave a copy with the lawyer. Sometimes people leave the original, but for me, I tell people put in your safe deposit box. And then I'll keep copy.
Yes, safe deposit box is great in case there's a fire or something. I will add though, make sure that your executor has access to the safe deposit box. Because if you die, you don't want it so that no one can now access the trust.
And then in that situation, I will put the person like on the safe, a signature on the safe deposit. And then they get to it. Fresh.
You've been so good with time. We're gonna take one last question.
Just really quick, do they have to be filed? Do the trust and wills have to be filed in the state where, not in Tennessee or any other state?
Well, I don't know.
Well, okay, let's say Tennessee, right?
I don't know, other trusts, other states, or revocable trust, absolutely not. It kind of depends on the kind of trust, because, and then sometimes too, most trusts, but not all, have to have a separate EIN. A simple revocable trust doesn't. So it kind of depends on the kind of trust, which George and I were just joking before we went up that the answer to every legal question
Depends.
is yeah, so we were just gonna say we don't have time for questions, so we're gonna answer all your questions all at once. Ready?
Well, let's do remind them about being able to email questions within 30 minutes from this point for free.
And it's free. It's free.
Right, on the paper that you got, at the bottom of the program that you got for our email addresses, and from this point, Ms. Lopez, they got 30 minutes for free. Now,
Well,
we'll
in
answer
the
your
end of
question.
the session, or because we got another session, I need them to be, one more presenter. I need them to be focused. So
Okay, let's do this, 30 minminutes after the next.
After the next session. Right.
That's the next present.
Okay.
Okay.
Okay. Hopefully that gave you better insight into how a signature session will take place. Some people go to their local banks, their libraries, UPS stores. As I've already mentioned, we have a mobile notary, somebody that does it over Zoom. However you do it, don't delay and make sure that is taken care of. The final thought that I have is you notice that those were the attorneys that run their office and their firm, that, but they get paid on fees. And towards the end, they were saying, like somebody could do a consultation and they would do a 30-minute consultation for free. Attorneys get paid by the hour, they get paid by fees. Uh, with the legacy planning process at Trusted Covenant, a lot of the information that that we go over, it's part of the education and it's part of your plan and it's part of sticking together with a plan that you can control and you can keep with you and you can share with all your family members. So the best plan is the one that you are satisfied with. The best plan is the one that serves your family's purpose for them remembering and acquiring the things that you have worked so hard for. But at the same time, no matter where you get your documents, Trusted Covenant is a place with a client portal for you to house the rest of the legacy plan. So even if you don't do the documents with us, that's one of the things that the portal offers. It's a total comprehensive planning, which no other office, attorney office is going to do for you. They'll hand you the documents and then they'll leave it at that. I hope this has been helpful. I hope it answers a lot of questions. If you have any questions further, um, either text or email, and I'll get back to you. Thank you.